This is Paul. Yes. I was just reading the self-represented person Superior Court civil proceedings, pro se litigant information. Yes. Now, it says here you will need to serve the other party through law enforcement, civil process, or an adult other than yourself. There has to be a declaration or return of service showing that you have served the other party. Which I would think that a declaration of mailing is not the same as proof of mailing. You can declare all you want, but if you don't have proof of service, then it's not actual service. Now, you now wait. If the other party does not respond within the prescribed time, the other party is technically in default. Though you need to obtain a court order stating that the other party is in default, you will still need to enter final orders in court that are consistent with the petition or complaint that you filed. If the other party side responds in time, then further proceedings such as motions and or trial are necessary unless you and the other party resolve the case. For most motion calendars list of cases to be heard by judge, it is mandatory to confirm, yes, that you will be present for the court hearing. Confirmation, if required, must be made in advance of the hearing. Call your county superior court for specific requirements. Approach. Now, you actually have to confirm that you're going to be at a hearing? Yes. Now, I just wondered that if you don't appear at a hearing and you didn't confirm that you were going to be there, how can a court have a court hearing? Now, this motion for dissolution of marriage where I responded within the 90 days, fraudulent default order. Yeah. It would seem to me that this whole fraud of continuing to enforce court orders, it's really getting to be a pretty good sized fraud, isn't it, Fooch? As a pro se litigant, you confirming that you're going to be in court? Yes. You did confirm that for the dissolution of marriage, didn't you? Yes. You were there on February 11th of 2013. There's no possible way that you didn't appear in court because I didn't get notice of court hearings. I didn't get the dissolution of marriage. Now, do you have to appear in court hearings when you issue protection orders? Because as I see it, there's no signature of the petitioner there. Is it something that you inform the judge, well, I will or will not be there after the temporary protection order was reissued? Then you reissued it again on June 12th. It's like one of these verbal assents that let's say you're in court and you reissue the protection order on June 1st of 2015. Yes. Now the petitioner would have been there. Yes, she would have. And she would have said, yes, Judge, I'm going to be at the next court hearing on June 12th because that's good for my calendar. And I am going to attempt service on the respondent. Yes. Now, a declaration that you mailed something is not the same as having a return, that's right, of the actual proof of signature. And it did say mail returned unclaimed, and you decided to have the court hearing anyway. Pow. Now there's a big question of February 13th of 2012. Did you intentionally have the court hearing and one of the court officers did know that the mail had been returned unclaimed and just inadvertently forgot to put it in the file because you as the Superior Court judge didn't know that the mail was going to be returned 2 days later? Pow. Now, was the court sending out notice of hearings? Because well, it says pro se litigant. Yes, it is the actual petitioner's obligation to inform the respondent of court hearings. Yes. Now, you did, well, it says the clerk's office may take original documents, original signatures, filing your case, or adding to your file. Bench copies are required in most counties. Call your Superior Court for specific requirements. Now, documents need not be signed in front of the clerk. You may sign them ahead of time. Fill out all documents, forms completely in ink or typed, no pencils. Yes. Now, I'm thinking this is pretty much the same for every superior court. Yes. Now, they give you a whole bunch of terms that you should know. You want to defend yourself from an action started by someone else. If an action, yes, has been started by another party against you, you are the defendant or respondent or responding party. Yes. Now, your answer or response to the petition filed against you must be filed in the clerk's office within the time indicated on the summons. Yes. Be sure to serve a copy on the opposing party. Now, as I remember it, I did take it to the sheriff's office. I did pay $65 so that the opposing party, known as Heidi Lee Budget, would be served within the 90 days allowed by law. After you have answered, the other party is required to notify you of any further proceedings. Number 2. Yes. Now, it looks to me like the other party did not do what's required and notify me. If you do not answer, respond in a timely manner to a summons, you may be found in default and lose the right to have your side of the case heard by a judge. Now, these petitioners known to motion a court for protection order, yes. Uh, I don't think I was given the right to answer, was I? I mean, you don't give me notice, and then you don't allow me the opportunity to be heard, and I might have even responded. I'm not a domestic abuser. I'm not a child abuser. Could have put it in writing, isn't that right? I could have typed up a little letter, and you what? Well, you have after you have answered, the other party is required